Hello there, welcome back to the channel. If you're a business owner with a website or thinking about launching one, today's topic is a must-watch. We are going to talk about why having a solid terms of service and privacy policy for your business website isn't just a good idea, it's essential. Whether you're a startup or an established corporation, stick around to find out why these legal documents are your first line of defense. Let's start with the terms of service. This is a document that outlines the rules and guidelines for using your website. It's a legally binding agreement between you and your users. Think of it as a contract that helps protect your business. It typically covers key areas like acceptable use of the website, intellectual property rights, limitation of liability, and dispute resolution procedures. By having these terms, you're setting clear expectations for how visitors can use your website. And there are 4 clauses that you should definitely include in your terms of service to further protect your business. Let's dive into 4 critical clauses that every business should consider including in their terms of service. First up is the amendment clause. It is important to let users know that your terms of service can be modified or updated from time to time, and that these changes will be binding on them. Why? Because as your business grows or as laws change, your terms may need to be revised or amended. By including this clause, you ensure that users are bound by the most current version of your terms of service, so that you don't have to seek their consent every time you update your terms. Next, let's talk about the payment terms clause. If your business involves online payments, whether for products, services, or subscriptions, it's essential to clearly lay out the payment terms. This clause should cover everything from accepted payment methods to when payments are due and what happens if a payment fails. This way, you avoid misunderstandings or disputes down the road. The third crucial clause is the warranty disclaimer. This is where you state that your company makes no warranties, whether express or implied. That includes warranties of title, merchantability, satisfactory quality, non-infringement of third-party intellectual property rights, or fitness for a particular purpose. In simple terms, you are telling your users, we make no promises about how well the products or services will work for you, so use them at your own risk. Without this clause, you could end up in a situation where a user claims that your product didn't meet the expectation and then tries to hold you liable. Lastly, the limitation of liability clause. This is perhaps the most important protection for your business. It limits the amount your company would be responsible for if things go wrong. For example, you might limit your liability to the amount that the user actually paid to your business or to your company. So if you are found liable in court, your financial exposure is capped. Without a strong limitation of liability clause, you could be on the hook for much more than just the cost of the product or service, potentially even facing damages that could cripple your business. Now let's talk about the privacy policy. Unlike the terms of service, which focuses on protecting your business, the privacy policy is designed to protect your users, and it's required by law. A privacy policy outlines how your website collects, uses, stores, and shares personal information. This includes things such as names, email addresses, payment information, IP addresses, or any other data that could identify a person. If your business website collects any form of personal data, you need a privacy policy, period. In Singapore, the Personal Data Protection Act sets out clear guidelines on how personal data must be handled. Failing to comply can lead to hefty fines or even lawsuits. A privacy policy also builds trust. When users know that their data is being handled securely and transparently, they're more likely to engage with your business. It's not just a legal necessity, it's good business practice. So what happens if you don't have a solid terms of service and privacy policy in place? Well, the consequences can be severe. Without these legal documents, your business could face lawsuits, fines, and the loss of trust from your users. You could even end up paying hefty damages if your terms of service don't limit your liability appropriately. Even if you're a small business or a startup, these policies can protect you from unnecessary risks and liability. In short, you can't afford not to have them. So how do you get started with drafting these documents? Well, there are a few options. Number 1, consult a lawyer to draft custom policies for your website. Number 2, use a trusted legal template and modify it to suit your business. You should ensure compliance with laws such as the PDPA in Singapore or the GDPR in the European Union, depending on where your users are located. The key is to make sure that your policies are tailored to your specific business model. If you're handling sensitive data, you might need extra provisions. It's always better to get professional legal advice to ensure that your documents are airtight. To wrap things up, having a terms of service and privacy policy for your website is crucial, not just to comply with the law, but to protect your business and to build trust with your users. If you don't have them in place yet, now is the time to act. Don't forget to like this video if you found it helpful and subscribe to the channel for more legal tips for businesses.